Ready? 3, 2, 1, start. It is also submitted by learned additional Advocate General that by showing conditional readiness and willingness in order to establish his bona fide consent in reply to application has been cleverly drafted in tactful manner so as to avoid adverse inference which could have been drawn during trial against petitioner under section 106 of Indian Evidence Act for refusal. Stop. It is canvassed that for permissibility of test during investigation, if consented by a person, the consent given in reply is a valid consent which cannot be withdrawn at this stage. Stop. Giving thoughtful consideration to submissions of learned counsel as well as pleadings of parties and also pronouncements of the Supreme Court, I am of the opinion that present petition must fail for reasons enumerated hereinafter. Stop. Protection granted under Article 20 within bracket 3 of Constitution is undisputed, which reads as under para. No person accused of any offence shall be compelled to be a witness against himself. Stop. 3 judges bench of the Supreme Court in Govind versus State of Madhya Pradesh and another reported in within bracket 1975 to SCC 148 has held that individual autonomy, perhaps the central concern of any system of limited government, is protected in Part 3 under our Constitution by explicit constitutional guarantees. Stop. Wide pronouncements of the Apex Court in Ritesh Sinha's case, the court has been conferred with power to direct a person to give a sample of his voice for the purpose of investigation of a crime. Stop. Therefore, issue in this regard is no longer res integra and thus petition on this issue fails. Stop. So far as issue with regard to direction to undergo polygraph test is concerned, there is no specific provision empowering the court to do so. Stop. However, as held in Salvi's case, the meaning and scope of term investigation includes measures that had not been enumerated in the statutory provisions and directions which come within the ordinary understanding of investigation can be given by court during investigation and where there is silence in the law with no statutory prohibition against the issuance of such direction. The court can issue the direction to a person to undergo test which is not expressly enumerated in CRPC circumstances, where an individual consents to undergo these tests. There is no dilution of Article 20 within bracket 3 of and in Constitution. Stop. As observed in Rajendra Prasad's case referred supra, it is expected from investigating agency to adopt latest advanced scientific technologies and methods of investigation to arrive at right conclusion. Stop. Over.